My name is Brian Cronin, and I'm very pleased to welcome you to this tutorial on approaching the EQE second approach, the working method. This tutorial is part of a series of audio slideshows entitled Approaching the EQE, made up of 6 complementary approaches as follows: 1, serving the client; 2, the working method, which is the present one; 3, legal thinking; 4, presenting arguments; 5, substantive law; and 6, time management. Here we will deal with the second approach, the working method. But what is the working method? For all papers of the European Qualifying Examination and for all EQE questions, there is a common working method that involves 3 essential phases. The first is read, which is purposive assimilation. The second is plan, which is organization and planning. We'll come to it later. And the third is write, or delivering the end product answer. You have to begin each new task, get involved in it, and finish the task always in a limited time. The EQE tasks are all fact-driven. How does this impact the working method? The working method for papers A, B, C, and D2, the legal opinion, can be resumed as follows. By purposeful reading, you identify and highlight facts that will lead to the legal consequences relevant for the given task. Then you will organize the facts and plan them to achieve the desired legal consequences. And in the last phase, you will extract the facts from the source documents and insert them in your answer as you write. I'll now deal with each of the 3 phases of the working method separately, starting with reading and purposive assimilation and beginning with some preliminary remarks. All EQE papers are in writing, possibly with drawings for the drafting paper, the amendment paper, mechanical, and the opposition paper. Each paper or each EQE question presents you with new information and new situation. You have to read each paper from the outset. It sounds obvious, but you have to begin by reading the paper. But time is always short in the EQE, so you have to read the papers efficiently, both in timing and in the quality of the information intake that you make. To be efficient, your reading must be purposive. We will call this purposive assimilation. The papers must then be read purposively, meaning that if you set out knowing what you are looking for, the chances of finding what you want or need when you read are increased. Each EQE paper sets a different task with a different purpose, and you have to look for facts that will influence the legal consequences relevant for that paper. Therefore, you have to approach each paper with its specific purpose in mind. Let's now consider ways of purposively reading each paper of the EQE in turn, starting with the drafting paper A. With the drafting paper, you can make a first reading or scanning, and the purpose of the first reading or scanning is to familiarize yourself with the terminology and the terminology represents the technical features that are needed for drafting the claims later. So it's essential to become immediately familiar with the terminology used by the client. Where you have drawings for a mechanical paper, you should write the names of the parts against the signs of the drawings to become rapidly familiar with the terminology and to associate it with the real world object of the invention. You can then make a second reading where you're looking for patentability, and the purpose of your second reading will be to look for anything that contributes to patentability, and this can be notably things like advantages that the client sets and so on. And you can also look out for words like essential, optionally, preferably, that contribute to a hierarchy of importance of the features. And this is important because the essential features will go into the main claim and the optional features will go into the dependent claims. So it's important to look at this on your second reading. On your third reading, you can look at the prior art, read the prior art, and the purpose of reading the prior art is to identify what cannot be claimed on the one hand, and also to identify information that you're going to be able to use for the background art for the introduction to the description. Let's go to paper B, which is the reply to an EPO communication. Purposive assimilation for the reply paper B then involves a first scan followed by purposive reading as follows, and you have the problem of knowing which order to read the documents, and I'm going to present you a possible order of reading the documents which is fairly efficient, but you can read the documents in the order that you feel most comfortable with. First, read the client's proposed amendment over the claims as filed, the purpose here being to familiarize yourself with the claim and with the proposed amendment, which is what you're going to have to be working on. Then you could turn to the communication and read the communication, consulting at the same time with the prior art documents, and the purpose of this reading would be to check whether the examiner's objections are correct. And in the EQE, so far, the examiner's objections have always been well taken. Then you could turn to the description, the client's description, and the first purpose would be to look for and check support for the amendments proposed by the client. Then you could read the description once again. Here it would be, the purpose would be to identify support for inventive step, advantages and effects, and so on and so forth. And you could also review the prior art, and the purpose of this review will be to detect any pointers away from the client's claim that you may be able to use in your arguments in support of inventive step. So as I say, that is just one illustrated example or one efficient way of tackling the documents, but you can read them in the order that suits you best. Next is the purposive assimilation for opposition paper C. With the opposition paper, you should start by reading the claims, and the purpose is to familiarize yourself with the opposed subject matter. Secondly, you should go to the client's description, and the purpose here would be to look for definitions of different features and counterparts to the claims, and in particular to look for effects associated with claimed features, and also possibly basis for amendments if amendment has been brought into the opposition paper. Next, you can come back to the claims and read the claims again while you're setting up your matrix. I'm assuming you're going to use a matrix. And the purpose of reading the claims at this time is to construe and understand the claims and to program your mind as a search engine, because you're going to be searching when you read the prior art documents for the features in the claims. Then you should or could read the description again, purpose being to consolidate understanding of the claims and possible variations of the claims so that you fully understand the pattern before you go into the prior art. And last of all, in your reading phase, you should read the annexed documents one by one, preferably read each annex twice. The first is to familiarize yourself with the document and get a general idea of what is going on. And the second purpose is to identify counterparts of the claimed features and definitions that you will be marking up in the matrix. That is the purposive assimilation for the opposition paper, and we'll now turn to the legal paper D, Part 1. Here you have several short questions, 4 or 5 or 6 questions, and you have to read each question individually, and you have roughly 3 purposes in reading the questions. The first is to identify the underlying legal bases that are related to that particular situation. The second purpose is to identify facts that lead to legal consequences. And the third purpose is to recognize any situation or any question that corresponds to a case law case or principles in the guideline. Questions are sometimes based on case law situations, and by reading the question, you should be able to immediately understand that the question is related to that particular case law. With the D1 questions, you have to finish each question before starting to read the next one. Now we turn to purposive assimilation for paper D2. For paper D2, this is a complex legal situation. First, you have to scan the complex legal situation just to familiarize yourself with its layout, to find out where the client's questions are asked and how many questions are asked and so on. Secondly, you should have identified the questions asked by your client, which are sometimes but not always indicated in bold typeface. And the purpose of reading the client's questions is to fathom out what you need to look for in order to reply to the question. So if you read the question and you work out what you need to look for to reply to that question, that's going to help you when you come to reading the main part of the paper. Then you could have what I call a light reading of each section of the complex situation, the purpose being, for example, to scan for dates and to start setting up your date diagrams, and just for familiarization with the situation. And lastly, you should make a detailed reading of the situation. Here you'll be looking out for any facts that lead to legal consequences relevant to each question raised by the client. That's how you can go about reading the D2 paper, Part 2. Now I propose to make a short summary of this first phase about reading or purposive assimilation. Firstly, the technique of purposive reading is the same for all of the papers, but each paper sets a different task, which implies a specific purpose for reading it. Therefore, you have to read each paper in a specific different way, always directed to the purpose of the task. When you're reading, you're mainly looking for and highlighting facts that will lead to legal consequences relevant to the task of the particular paper. I suggest that you practice purposeful reading in your preparations for all of the papers of the EQE, and you also practice purposeful reading at work, always trying to extract the information you need for whatever task you have to do. By the way, all patent attorneys practice purposive reading. Now we'll turn to the second phase of the working method, organization and planning. Here are some generalities. After reading and before you begin to write the end product or your answer, you have to organize the input information and make a plan of what you're going to write. You have to integrate a plan into your processing of all EQE questions, going from the shortest D1 question, so say a 5-point question, to the longest question, which is a paper C 5-hour question. It's the same. You have to make a plan for each and every question. When you're doing all of the papers in the exam conditions, you have a limited and a compressible time for making a plan between reading and the writing. And the organization and planning can be done, I said, ex situ, by which I mean pre-planning. You can do a lot of planning in your preparations by pre-planning what you're going to do. And your planning can also take place in situ. That is what you have to actually do while you're tackling the paper of the exam under exam conditions or during your practice. Let's now turn to specific points on organization and planning for the different papers of the EQE, starting with organization and planning for drafting paper A, having read the paper as we outlined before. For the main claims, you have to have a plan. Normally in the mechanical you have one main claim, and in the chemical you may have 2 or perhaps 3 independent claims. For the independent claim or claims, you have to focus on essentials, and you have to eliminate inessentials, and you have to eliminate what is prior art. During your plan, you can assemble and draft your main claims as you are planning, and you can test your patentability using the problem and solution approach, using what I call the votum for grant form, which I will show you when we come to the next slide. For the subclaims, you also have to make a plan. You have to list preferred and advantageous features. You have to provide a list of all of the features which could come into subclaims. And you have to accumulate rejects from your draft main claim. If you have a feature in your main claim which turns out to be not essential, that can be downgraded to becoming a dependent claim. And as part of your plan for the subclaims or your claim set, you have to arrange and group the features of the subclaims into some logical sequence. That will be your plan for the subclaims. For the description, you have to write an introduction, and here you have to identify of the prior art documents. There are usually 2 prior art documents. You have to identify which is the closest prior art document that you're going to take for your introduction, and you have to make a problem and solution outline or plan for handling the introduction, and you can also use the votum for grant for doing that. For your subclaims, I'll come back to the subclaims, you have to arrange the features, subclaims from broad to narrow, roughly speaking, and you have to cover the different embodiments of the client's invention, and you have to work out proper claim dependencies to have a coherent set of claims. For the description, you can do your planning for the description at the same time as you're doing your votum for grant planning for patentability of the main claim. Now I'd like to turn just to this votum for grant, just in case you're not familiar with the concept. The votum for grant is an internal EPO form. It's mentioned in the guidelines. The main examiner, you have 3 examiners on an examining division, and the main examiner fills up the votum to present this form to the 2 other members of the examining division to get their agreement on patentability if the patent application is to be allowed. Now, if you think about it, if you want to have a European patent application accepted, you need to convince the examiner to fill the votum form in such a way that he will recognize allowance. You can use this votum form for your own purposes for checking patentability in the A paper and also in the B paper. And the votum consists of an outline. It's a blank A4 sheet which has the following 4 rubrics: prior art or the closest prior art, the problem, the solution, and reasons for grant. And you can use this, you can fill it up as convenient and use it as a central part of your plan for patentability before you finalize your claim. Next is planning for paper B. So the organization and planning for paper B then is that firstly you could check if your client's proposal, your clients will make a proposal for amendment of the claim, whether this overcomes the objections. Normally it is imperfect and you have to correct the client's proposal. Secondly, you may want to develop any further amendments. Thirdly, you may want to use a votum for grant format to plan for the patentability and the arguments that you're going to use in support of patentability. And you may want to use your votum and the other papers to make an outline of your plan for the reply, and your reply will consist of a letter to the EPO following a predetermined format, and it will follow, roughly speaking, the following features. Firstly, basis for amendments, which can be notes on the description. You have to always put in the basis for the amendments, why the amendments comply with Article 1232. You have to discuss novelty. You have to discuss the distinguishing feature or features of each annexed document of the claim over each annexed document. You need to identify the closest prior art because you're going to do a problem and solution approach, and the closest prior art can already be dealt with in your votum plan. You need to identify the distinguishing feature of the claim over the prior art, and that is something you can do as part of your votum plan. You need to identify the effect of the distinguishing feature over the prior art, and the effect can be highlighted in the description, and it can be mentioned possibly also in your votum. You need to establish what is the objective problem that has been solved, and you can do that again using your votum sheet as a planning tool. And you need finally in your plan to set down the reasons for the unobviousness of the claim, and you can do this by making notes on the various documents. Next is organization and planning for paper C. During the reading phase or the information input phase, I suggested that you use a matrix, and if you have done that, your first step of your planning will be to scan the matrix horizontally, that is claim by claim. Starting with claim 1, you scan it claim by claim, and you identify the potential attacks against claim 1, and then you go to claim 2 and you scan horizontally and you identify the potential attacks against claim 2, and you go down through all of the claims until you have identified some potential attacks. Then you have to check and highlight support for your lack of novelty attacks. You may have done this partly during your planning phase, this is the planning phase, I'm sorry. You need to highlight the support for your novelty attacks, and you can do that by highlighting on the documents. You need to check for support for lack of inventive step attacks. The effect of the feature can be highlighted in the client's description, or the opposed patterns description rather, and you need to check for guidance in the secondary document that you're going to be using, why perhaps the same problem has already been solved, so that you can check that you can make out an argument for lack of inventive step. And as you build up your list of attacks like this, you make a list of these attacks in a claim-by-claim plan in the format claim ground document, that is claim 1, lack of novelty, article 54, document D3, and so on. And you list all of your attacks, ready to write your attacks when you come to the writing phase. You can write your plan, or I write my plan for the opposition on an extension sheet which I stick beside the claims. So I have the claims and the attacks against the claims all on one sheet. Next is planning for D1. So after reading each short situation or each question of D1, first of all, if the situation involves dates, you make a date diagram. Secondly, you identify the legal base or the legal basis governing the situation. And thirdly, you identify the facts that produce legal consequences. And thirdly, you work out the answer to the question or the advice you have to give to the client by legal reasoning. And you make a plan for writing your answer in a particular sequence, which will depend on the structure of the question, and it will depend on your personal inclination. If the question lends itself to an answer yes or no, it can be convenient to begin your answer with yes or no and say what you have replied to, and then put the legal reasoning afterwards. So you must, it's very important for D1 questions, as all questions of the exam, to complete your plan before you start writing. If you start writing your answer to the D1 question before you've made a plan, the answer is likely to ramble on and come to an unfinished end where you have to stop somewhere. Let's consider next what we have to do for organization and planning for paper D2. First, you should make a date diagram for each segment of the situation. Secondly, you should gather and group the facts pertaining to each part of the client's questions. So you have the client's questions, and as you read through the paper, you should organize the facts so that they fit into answering the client's question. You have to work out legal consequences using the date diagram where appropriate. and you have to arrange the facts and legal consequences for each part of the client's question in a logical order. It's a good idea, or at least I think so, that as you arrange the facts and legal consequence into a set of notes for your answer, you are basically rehearsing the future written answer, and this is going to help you to write the answer quickly. Now let's have an overall look at the summary of the organization and planning phase. Organization and planning has to be adapted for each paper of the EQE. For each paper, the assimilated facts have to be organized as a function of the planned output or the legal consequences. The manner of organizing the facts, the manner that you organize the facts for each paper, and this applies except for D1, can be pre-planned ex situ. In other words, you can pre-plan the manner of how you're going to organize the facts for all of the papers except D1. For each particular paper, in any event, you have to organize the facts and plan them in situ, that is, while you're actually doing or during the exam. And you have to complete your plan in situ before you start to write the answer. This applies to all papers of the exam, including short D1 questions, as I mentioned before. Some more on planning. Pre-planning and in situ organization and planning for each paper. In the exam, time is short for in situ planning. We tend to squeeze, the planning phase tends to be squeezed time-wise. Therefore, you have to make the most of your pre-planning to streamline the time you need for planning in situ, that is, for planning actually during the completion of the particular paper. So during your preparations for the exam, you have to spend some time to set up an organized way of tackling each paper. Practice plan as you read. So part of your in situ planning is anticipated. What this means is you can do two things at once. As you read, you are reading forward as part of the planning phase, so you can do some of your planning as you are reading, that is, you can advance the planning phase, but you should avoid what I call plan as you write, that is, start writing and make up your plan as you go along, which is inefficient. I won't say why, but it's inefficient except for claim drafting in paper A, where you plan as you write. In other words, you draft your claim as you write, or you write your claim as you draft it. I'll now turn to phase 3, writing the end product or answer. In my opinion and in my experience, premature writing is a major cause of failure in the EQE, that is, start writing before you have properly read the documents and before you have formulated a plan. You must defer writing the end product until your, what I've called the in situ plan, is complete. It applies to papers B, C, D part 1 questions and D2. It does not apply to paper A. For drafting paper A, you may plan and write segments of the end product sequentially, the main claims, the subclaims, and the descriptions, with planning in between. So the drafting paper does not fit into the same pattern as the other papers from the point of view of planning. It's more difficult to plan the drafting paper. During preparations, when you prepare by doing past papers for the exam, it's useful to practice the writing phase or the end product separately and to do it under timed conditions. For example, in the opposition, you can spend quite a lot of time reading the papers and making up your plan. And once you've made up your plan, then you can write individual attacks against the different claims, one at a time, each under time conditions, so you get a good idea of how fast you can write your answer. And the same applies to the other papers. Let's turn now to the drafting paper A. First, you should separate the drafting paper has three components of the answer, which is the main claim, the subclaims or the set of claims, and the description. And you should separate these three components. You should write each of these three components separately, and you should complete your plans in between the writing. To produce the main claim, you may write several drafts main claim, which means that your in situ plan of what the main claim will be builds up as you write. You can discard your draft claims, except that you may want to possibly keep the last draft and use it and not rewrite it if time is permitting. And also the discarded draft claims can be used as part of your plan for drafting a set of claims. You should write a set of subclaims in one go from a list, and you should practice in your exam preparations and at work writing a set of claims all in one go, for example, from a list of features. And you should also write the introduction to the description in one go from your votum for grant plan. And you should do this also in your drafting at work. The difference being that in the exam you have a streamlined introduction where you are only expected to discuss the closest prior art and the problem and solution. And I suggest that you use the exam format in your everyday work, and then possibly complete your everyday work with discussion of 10 or 15 prior art documents, as the case may be. So write your EQE style introduction in one go. Next is writing for paper B, the reply to the communication. For paper B, you should write the reply letter in one go after having completed your plan. In other words, you shouldn't build up the letter piece by piece. Always follow a standard format for writing the reply letter, and at work, use the same format whenever you reply to an EPO communication. Always use the standard letter format for the EQE. When you use your standard letter format at work, practice filling in the gaps with the facts according to each case as you deal with them. In other words, you start with a format and you fill in the facts. For the EQE, to complete the arguments, as you write, you have to extract the facts you need from the client's description, from the amended claims, and from the annexed prior art documents. So you should have highlighted these facts when reading and when planning to facilitate extraction of the facts when you're doing your writing. Now we'll turn to paper C. For paper C, you should write the statement of opposition in one go after having completed your plan. This means sustained writing for about 2.5 hours. You should check each attack before starting to write the next one, checking each attack gives a short break and rests your writing hand for a few seconds before you start writing the next argument. You can also revise your, before you go to the next attack, you can revise your plan for the next attack before writing it. So you have 2.5 hours of continuous writing with stops, short stop in between each argument. Writing novelty attacks using a word-by-word equation requires very great concentration and is very time-consuming, and you have to practice it. You have to practice it with the claim, shall we say, on your left-hand side, with the source document on your right-hand side, and you integrate the facts from one document and the other into the argument as it runs along. It requires a lot of concentration. Attacks for lack of inventive step using the problem and solution approach are relatively long. If you look at the candidates' answers in the examiner's report, you'll find that the attacks are rather long. But although they're relatively long, the problem and solution format helps the delivery of the argument, so it can be written reasonably quickly. You should, as before, have highlighted all the relevant facts in the source documents to facilitate extraction of the facts as you write. When you practice on past opposition papers, space apart your writing on individual attacks. In other words, it's not necessary to write all of the attacks in one go, but it's useful, for example, if you do the opposition paper, shall we say, on Monday and Tuesday for reading and planning, on Wednesday, Thursday, and Friday, you could write up a series of separate attacks against the separate claims. And it's necessary that you should become efficient in writing up single attacks against the claims, because you have to be efficient in writing up a single attack before you can hope to be efficient in writing up a series of attacks. Okay then, let's go to writing for D1. Here I repeat myself, you should not start writing the answer to any question before having worked it out. Always structure your answer sequence according to the question's structure and according to your inclination as to how you approach the different facts. As I mentioned, if you can make a yes or no answer, it's convenient to put the answer yes or no first and the legal reasoning and legal basis afterwards. The content of your answer should repeat the terminology of the situation. In other words, you repeat the words from the question and you paraphrase the appropriate legal provision. But it's no use to simply repeat the question. You have to repeat the question and integrate the legal wording into it. So it's a complicated operation. You must always indicate the legal basis for D1, and you can do this in parentheses, and the advantage of doing it in parentheses is that it will encourage you to adopt a writing style for legal arguments which is suitable also for the Part 2 legal situation, where you write exactly the same way, simply you leave out the legal basis. Lastly, for the D1 questions, you have to practice writing the answers on old exam questions under time conditions. I recommend that you spread out your answering of legal D1 type questions over a fairly long period. And I also recommend that instead of trying to do as many different questions as possible, you should do a limited number of questions, but each time try formulating your answer or structuring your answer in different ways. We'll now turn to writing for D2. For writing in D2, you should not start this writing before you have worked out all of the legal consequences of the complex situation and before you have planned your answer for each segment or each set of the client's questions. It's convenient if you use the client's questions to structure your answer and you answer the client's questions in turn, starting with the client's first question, then the client's second question, and so on. It is good because it helps to identify what you're talking about, and it makes it easier for the examiners to identify whether you have answered the question. As I mentioned, you can use the same writing style as for the D1 questions, but simply leaving out the legal basis. As I mentioned also, if you rehearsed your answer as you made your plan, in other words, as you are gathering together your legal consequences and advice and facts to make up the plan for your answer, you are rehearsing the future answer, and this is very helpful because you have to write your answer very quickly and efficiently. And if you have rehearsed your answer, your writing efficiency is greatly increased. And there again, like I said for the opposition paper, where you can practice writing up segments or for the opposition paper different claim arguments, for the part 2 questions you can write up your answer segment by segment and spread your answer out over several days. Now we have some generalities on the writing phase. Firstly, incorporating facts from different documents, which is what you have to do as you are writing, is time-consuming and needs practice. You have to practice doing that in your preparations for the exam, and you should practice doing that at work. Writing for more than 2 hours in the opposition paper can be exhausting, and you need some practice in writing, and you could practice having short breaks between each successive attack so that your writing hand doesn't let you down as you get towards the end. As I've said before several times, it's useful to practice writing segments of answers under time conditions so that you get an idea for the time it requires to write an answer. Writing is time-consuming, and once you have a good idea that you can write the answer, shall we say, in half of the time for the exam, then you have enough confidence to not to have to start writing until halfway through the exam. You may, however, have to accelerate during the last half hour of the exam, and you should set a silent alarm or something like that, and take note of where you are, revise your notes, and then write as fast as you can, writing in note form based upon your plan instead of necessarily consulting the document, so you can write faster by going from the plan. Lastly, if you use a word processor at work, it's a good idea to practice handwriting, and you can do this in conjunction with doing past EQE papers. Here now is a summary of the working method. The working method is read, plan, write, and it applies to all of the EQE papers and all of the EQE questions. Purposeful reading is done as a function of what you need to complete your plan. The plan organizes the assimilated facts as a function of legal consequences. Writing your answer follows the plan. You must not begin writing the answer until your plan is complete. And the time for your in situ planning, that is the planning you have to do on the day of the exam, can be compacted by ex situ or pre-planning, mainly by pre-planning, and also in situ by forward planning, by doing some of your planning during the reading phase. How now can you adapt your working conditions to the EQE working method? Three aspects of your job may clash with the EQE working method as I've described it. Firstly, your work may be dispersed. Your work can be spread out over long periods. Secondly, you may be doing what I term multitasking, that is, you are doing several jobs at the same time, or on the same day, or on the same morning. Thirdly, you may not have complete starting materials, and you're unable to complete the job in one go. So the conditions that you work under in the office are somewhat different to the conditions on the day of the EQE exam, and I would like to suggest that you take two opportunities to compensate for this. Firstly, you can reorganize your working style as far as possible. Now, you as a trainee have quite a lot of say in the way that you organize your work, and so it should be possible for you, for example, to group together certain activities, such as if you're drafting, to make sure you gather together all materials, and then you draft your main claims in one go, and then you gather together all of your materials for the subclaims, and you draft a set of subclaims in one go, and you draft an introduction to the patent application for EQE conditions. You can mimic that in your everyday work. So what you can do is, as far as possible, you won't be able to work exactly as in the exam, but you will be able to partly work as in the exam, so that the difference will not be too great. And second thing that you can do is, if your working conditions are very different, it means that you have to practice on the EQE questions. Now, I have mentioned several times, it's not necessarily a good idea to do the questions all in one go, and you can split them up. But it may be that if your working conditions are such that it will be a good idea for you to practice doing the EQE questions more or less under exam time conditions. I don't think you should do that immediately, but at least during the last part of your preparations. What next then? Next in this series of tutorials on approaching the EQE is a tutorial entitled Legal Thinking, where I will investigate the paradigm fact, legal provision, legal consequence. And we will investigate legal consequences in the EQE, and we will also talk about why legal consequences are so important for the job of a European patent attorney. So I look forward to your participation in the upcoming tutorial and the further tutorials in the series. Now I have some closing words. This brings our tutorial on the working method to an end. I hope it has been of some value to you. You will get the most value if you implement the working method in your exam preparations on past EQE papers, and by aligning your working habits as far as possible, so you get one job or one aspect completed at a time. Be on the lookout for upcoming tutorials on other EQE subjects that I will be announcing on the PatSkills blogspot. And for further guidance on EQE preparation, you can, and I recommend that you do, consult the book EQE Comprehensive, which is available on the internet from the site shopmybookallinoneword.com. That is the new website. It was formerly called sorry, Shop My Book is the old website. CreateMyBook.com is the new website. So it's CreateMyBook.com is the new one. Search word Pat Skills. À bientôt.